have to give you a notification that this hearing is being recorded in accordance with the requirements of the open meeting law and broadcast over the Lunenburg Public Access. Before I start the hearing, I would just like to say that it is with sadness that I announce the unexpected passing of Paul Doherty, a 12-year member of our board. Our condolences go out to Paul's family and friends, and Paul will be greatly missed by this board. And I would like to have a moment of silence, please. Thank you. The way the hearing will proceed, I'll introduce the board members. Our board secretary, Lisa Normandin, had surgery this week, so she is not here tonight, but we will wish her a speedy recovery. Alfred Gravel, this is Jane Bezikowski, Hans Winthrop, and Pat Callahan. The way that we will proceed is we will read the application and any other submitted communications. The applicant will have the opportunity for comments on the application or submission of additional documents. You will please come forward to the mic and give your name and address. Board members will have the opportunity to ask questions that they might have while on the application while you're at the mic. There will be a public comment period. Again, you'll please come forward to the mic, give your name and address, and please address all comments and questions to the board. And with that, I will read the application. This is an appeal from a person aggrieved, Mass General Law, Chapter 48, Section 8, Zoning Board of Appeals. The undersigned appeals from March 18th, 2019, determination of the building commissioner. The basis for this appeal or petition for a variance concerns the following section of the Lunenburg zoning bylaw, section 250-8.3B1. The street address or other sufficient description to adequately identify the land or building which is the subject of this case. Street address 300 Holman Street and 300 Holman Street West, Lunenburg, Mass. Assessors map and parcels 021-0011-00 and 021-0017-00. Name and address of each holder of legal title to the land which is the subject of this case, listed as it appears in the deed, is Darren C. Massey. Date recorded, Whiston North District Registry of Deeds, Book 8193, page 107. Deed recorded 9/17/14. If the undersigned has any knowledge of a prior appeal, application, or petition concerning the land or building involved in this case, describe the case and the dates involved. A previous application was withdrawn without prejudice. If the appeal is based on a belief that the planning board or the building inspector made a mistake in the interpretation of the zoning bylaw as related to this case, specify the alleged error and the reasons for your belief on another page and attach. And it's check page attached. And this is signed on the 14th day by Darren C. Massey, 300 Holman Street, Lunenburg. There is a oversight view of the property, and there is an attachment to the appeal regarding 300 Holman Street. It is and the title is Errors of the Building Commissioner. This is an appeal from the Building Commissioner's cease and desist order dated March 18, 2019. The appellant contends the determination was erroneous for at least the following reasons and requests that the determination of the Building Commissioner be reversed and vacated. Factual background. This order concerns 300 Holman Street. The parcel consists of approximately 140 acres, most of which is in the outlying district, but approximately 4 acres of which is in the commercial district along Chase Road. On or about April 25th, 2017, the Building Commissioner issued an opinion that an event licensed by the Board of Selectmen, an event which spanned 4 days, was not a violation of zoning. more recently presented with a complaint from 13 neighbors, as the building commissioner describes them, only 9 of whom have a statutory abutters. The building commissioner opinion that a series of events constituted a violation of zoning. On March 18, 2019, he ordered the appellant to cease and desist from the use of 300 Holman Street property for events that are prohibited under the zoning bylaw. Procedural issues, burden of proof, and standing. Neighbors have the burden of proof. It is clear from the case law that the burden of providing that a use of property does not comply with the zoning is on the interested parties, not the property owner. The building commissioner's process turned that upside down. He indicated that he received complaints from some neighbors regarding some uses of the property. Appellant is not aware that any independent investigation was conducted. Based on the neighbor's list of events, he wrote to the appellant and request that the appellant finish a legal memorandum explaining how he complies with the zoning bylaw. This is not the correct standard. The property owner does not have to prove he complies with zoning. Not all abutters have standing. The law requires that notice of hearing of this matter be given to abutters within 300 feet of the property line. They still have to demonstrate standing. As noted, this property consists of 140 acres. The actual location of proposed events on the property is hundreds and hundreds of feet away from the abutters. The nearest abutter approximately 800 feet. The board should make a site visit to determine which neighbors have a considerable interest under the zoning ordinance. As noted, 4 of the neighbors are not even on the statutory abutters list for this appeal. Education and conservative uses. Educational uses defined very broadly by statute and bylaw, and conservation uses are allowed in the outlying district. The 3 proposed events, which include lectures related to the events, plainly have an educational component. There are 2 educational uses, one statutory under the state law and the other as defined in the bylaw itself, even if, as the building commissioner suggests, arbitrary and capricious. The determination of the building commissioner is the epitome of arbitrary. He is on the record as stating that a single event, which spanned 4 days, does not violate zoning without any articulated rational basis. He then concludes that the approximately 7 events a year alleged to have taken place does violate zoning, and he articulates no standard for his determination. Primarily residential use. Assuming arguendo that there were in fact 29 relevant events over a 3-year period, which there were not, as discussed below, there is no basis to conclude that so few events have transformed the primary residential character of the property. This is not a seasonal home where the relevant window is a few weeks during the summer. Even if some of these were multi-day events, that is well under 5% of a 365-day year. There is simply no basis to conclude that any of these events have altered the essentially residential character of the property. Moreover, the number of relevant events is inflated. For example, one event was a meet and greet for a candidate for state office, something private property owners routinely do and probably protected by the First Amendment. Another event featured the members of the Turkey Hill Gardeners meeting at the property. Without attempting to be exhaustive, the point is that the number of annual events is below the 7 calculated by the building commissioner. And so far this year, there have been none and just 3 proposed as discussed. Unconstitutionally vague. Finally, the decision of the building commissioner is hopelessly and unconstitutionally vague, failing to give the appellant any notice of what it is he is not supposed to do. He concludes by stating the property owner is to cease and desist use of 300 Holman Street property for events that are prohibited under the zoning bylaw. His attempt to address the 3 proposed and now licensed events is no clearer. These 2 are prohibited, if similar or equivalent to those complained of. The decision fails to articulate a clear standard to which the property owner can be expected to conform. The appellant reserves the right to supplement this memorandum and submit additional information at the hearing as provided in the application instructions. There is a list of abutters. And that is it. I will ask Jim if he will read the letters that have come in from other boards in the town.
Okay, from the Conservation Commission review from Matt Morrow dated May 13th, 2019. As stated to the applicant, there shall be no utilization of the Lane Conservation parking lot for parking of vehicles for this event, and there shall be no formal utilization of the Lane Conservation area for any activities. The public and any attending the event, of course, are welcome to take individual personal hikes, etc., outside of the event setting. From Patrick Sullivan from the Fire Department, May 17th. I would recommend denial of the appeal based on the reasons cited by the building commissioner. While the aggrieved applicant may have the best intentions at heart, the size and frequency of event activities on the property do not appear to be in line with the spirit or letter of the zoning bylaws. The concept of residential zoning is to limit commercial or other uses from interfering with the quiet enjoyment of one's home. It is apparent by the feedback from nearby residents that this is not occurring. Based on previous activities and public advertisements, it would appear that the applicant's wish is to utilize the property as an outdoor venue. The town has at least 3 similar locations, at least in broad concept, for outdoor events: Shady Point Campground, North Leominster Rod and Gun Club, and the Lunenburg Sportsman's Club. These locations are zoned for their activities and are subject to oversight, inspection, and enforcement based on that zoning. From a public safety viewpoint, the factors of crowd size, traffic, types of activities, potential hazards, and emergency vehicle access all have to assessed for each event. While a single event does not necessarily create a significant impact for public safety, assessment, preparation, and response for multiple ones will. While the largest event referenced did not create a major strain on public safety, that is not necessarily an indication of events to come. I would echo the building commissioner and land use director's previous suggestion that the applicant pursue a zoning change based on a formal detailed business plan for the property. Respectfully, Patrick Sullivan, Chief. From James Garaffi, the Board of Health has on numerous occasions provided the owner of this property with information and regulatory requirements for the events proposed for the site, and I have conversations with the owner regarding the limitation of on-site sewage disposal system serving the house on the property. The Board of Health can't permit activities or events for which a license or permit is required unless the owner has complied with specific regulation governing the activity or event, including but not limited to the following: family-type campgrounds, bathing beaches, food service, water supply, and on-site sewage disposal. Furthermore, we would not recommend the issuance of an entertainment license unless the proposed event activity complies with the regulations governing the event or activity. Jim. From the Town of Lunenburg Building Department, Gary Rhodes, dated March 18th. The following determination and order is issued by me in response to a request for zoning enforcement received from certain neighbors of yours, all named and CC'd below, dated December 3rd, 2018, relative to your use of property at 300 Holman Street for certain events. 29 events were identified in the correspondence from your neighbors during the period December 13th, 2014 through October 26, 2018. That is approximately 7.5 events per year. I am unaware that several additional events are proposed for the property for which you have requested entertainment licenses from the Board of Selectmen. Upon receipt of the above enforcement request, I notified you of it and requested you from any information that supports the zoning compliance of past and future events at the property. I am now in receipt of a legal opinion provided to me on your behalf by Attorney Bowen, which I have reviewed. I have also consulted with town council relative to the nature of the events you have hosted, their frequency, and applicable provisions of the town's zoning bylaw and Massachusetts law. First, I stand by my statement contested by Attorney Bowen, that generally only residential uses are allowed in the outlying district. Exceptions do exist in the bylaw for exempt institutional uses, municipal uses, agricultural uses, and conservation land, as well as a few others. But bed and breakfast establishments, which are residential in many respects, are the only commercial use allowed in the outlying district. No other commercial, heavy commercial or industrial uses are allowed, either by right or by special permit. Both indoor and outdoor entertainment are prohibited in outlying district. Second, it is my opinion that your events do not qualify as an educational use, either under the zoning bylaw or general law 40A, section 3. To qualify for the educational use exemption, the land must be owned or leased by the Commonwealth, by a religious sect or denomination, or by a non-profit educational corporation. And further, the facility must be operated primarily for educational purpose. Attorney Bowen's letter does not establish, nor is it accompanied by any information, documentation, or other evidence providing that these requirements have been met. Third, your interest in using the property to enhance the enjoyment of the land, when accompanied by regular events of the sort described in your neighbor's submittals to me, is not conversation use as defined by zoning bylaw. It is the substance, not the form, of the tenderness gathering places, use, and operation of the land that controls. I do not believe your use of the property for frequent events complies with any allowed uses set forth in the zoning bylaw. Zoning bylaw 250-4-1B provides in relevant part, quote, any use not specifically listed or otherwise permitted in a district herein established shall be deemed prohibited. Attorney Bowen's letter states that you are very interested in using your property to enhance the enjoyment of the land and promoting the arts, culture, and conservation. I remind you that when you met with me and Adam Burney, Lunenburg's land use director, in March 2017, we indicated to you that what you were proposing did not comply with zoning bylaw. You were encouraged to work with the planning board about possibility of a zoning change to accommodate your ongoing uses of the site. Despite that recommendation, it is my understanding you have not pursued this course of action. Also, during our March 2017 meeting, we discussed your proposal at the time, for a one-time event. I opined that because the proposed event was limited in scope and duration, it would be allowed if the Board of Selectmen issued an entertainment license. Since that time, however, you have held several more events. Again, I understand that you are currently requesting additional entertainment licenses from the Board of Selectmen for further events. It is my opinion that these events, if similar or equivalent to those complained of by your neighbors, are prohibited by the zoning bylaw. In conclusion, you are hereby ordered to cease and desist the use of 300 Holman Street property for events that are prohibited under zoning bylaw. Please be advised that you have the right to appeal the above determination and order as provided for in the zoning bylaw 250-8.3B1 and general law 40A, sections 8 and 15. Sincerely, Gary Rhodes, Building Commissioner.
Thank you. Okay, and we also have received lots of correspondence from additional people. There will be a public at the end.
This has to do with one of those letters that was just written. I'm a member of one of those boards.
Okay?
Dave Passios, 56 Whiting Street, member of the Board of Health. I just want this board to be aware that the letter from Mr. Garaffi was his thoughts and maybe our chairman's thoughts, but it was never brought before the board and we never voted on a response. So I want that to be clear, that that response is not from the Board of Health, it's from the agent from the Neshoba Board of Health.
Okay, thank you. Okay, again, I have received a number of letters, many of them from residents, many of them signed by multiple residents. I'm not going to read all of them. I'm sure that a lot of you are here. So again, if you have written something in, when we open up the public part of the, if you would come forward to the mic and you can say anything you want at that particular time. And if you request that I read it, I will do that. So at this time, I would invite the applicant to the mic, speak to the issue. There is one other thing I would like to point out to the applicant while you were here. As you can see, this usually is a 5-member board with the passing of one of our members and with one of our other members out of the country at this point, not available. You can either go with the 4 out of 4. As you know, vote to overturn the building commissioner would need 4 out of 5, or it would need 4 out of the 4. We can do the Mullen Rule, which the town adopted in 2006, and we will move forward with the hearing. We will do it all, but what I would do is I would continue it to a date certain and let the 5th member review all of the tapes and documentation and allow him to vote by filling out the Mullen Rule.
I would certainly be willing to operate under the Mullen Rule. That seems like a very sensible approach for this difficult situation, and I do, on the behalf of myself and the applicant, also extend our condolences at the unfortunate passing of Mr. Doherty. He and I didn't agree on a lot of things, but he worked very hard for the town, and I too am sorry to see what happened.
Thank you.
The Mullen Rule makes perfect sense to me, and also to the extent that the board is relying on letters that you've received that are not being tonight read. I appreciate that in the interest of time and hearing from everybody that's here, but we would also like an opportunity to see those and respond to those, and if there's a continued hearing, that would certainly permit an opportunity to do that.
We would absolutely give you all copies.
Great, thank you. Just some brief introductory remarks. Tonight is part of a larger story, and the building commissioner in his letter, his cease and desist letter, has alluded to that. He admonished Dr. Massey for not going in front of the planning board to talk to them about a new use. We've tried, not in 2017, but recently we have tried. We were in front of the planning board, I think at their very next meeting after that letter was promulgated, for the express purpose of having that conversation with them. I did not attend that meeting, and I can't tell you why that conversation did not take place. It was on the agenda. It didn't happen. We also proposed our own new use bylaw that was on the town meeting warrant, and we met with the planning board in the context of their hearing on that on 2 occasions. They told us that they were uncomfortable with our approach, and I appreciate that, but they have not provided any substantive feedback, so we've been trying to have that conversation, but we haven't had it yet. We haven't fared much more successfully in front of the Board of Selectmen when we were there to discuss the 3 entertainment licenses that were also alluded to in the building commissioner's decision, which, just for the record, were granted by the Board of Selectmen, but are now the subject of an appeal. When we were in front of them at that time, I also invited them to have a conversation with us about the related proposal for a special event permitting process, either by bylaw, as we had proposed to town meeting, or as the Board of Selectmen seems to prefer by Board of Selectmen policy. I invited a dialogue with them about some of the issues that would resolve this dispute more globally, but at the moment they seem content to work independently on their own policy, which is certainly their prerogative. I would urge, though, that somebody give somebody guidance, not only to Dr. Massey, but to the town in general. Since our last meeting, there has been another applicant to the Board of Selectmen for a 3-day special event permit on 9 acres, not 2 miles away from this location. Somebody needs to give some guidance to all of us, and tonight, or at least this hearing, if it's continued, is an opportunity for this board to do that and to send this back to the building commissioner for further analysis with some guidelines, because we think that his opinion is erroneous in at least 5 different ways, and I do have an additional legal memorandum laying out some of the facts, and I won't read it all into the record, and I'll just make some summary remarks, but I have 4 copies for the board. There's 1 original on top and then 3 other copies. I do have a copy for Mr. Dombrowski. And just to summarize, there are 5 basic reasons why we think the decision is incorrect. First, the building commissioner has impermissibly shifted the burden of proof to Dr. Massey when it should be on the people who are seeking the zoning enforcement. Second, as we'll discuss shortly, his decision is unsupported by the evidence. He didn't, as far as I am aware, conduct an independent investigation into the 29 alleged events. He simply took as gospel that these events occurred. We think an actual investigation would have showed that at least 6 of the events just did not happen. The complainers actually admit in their list of complaints that one of the events didn't happen, but it's still in their list. I don't know why it's in their list if they admit it didn't happen, but there are at least 6 events that didn't happen. At least 2 of the events were political gatherings to meet a candidate or an office holder, which people routinely do on private property all the time. The majority of the events were private gatherings, and people use their residential property for these types of things all the time. There were maybe possibly 4 larger events that might raise some questions, and we can discuss those, but 4 would translate to 1 a year, which the building commissioner is already on record as saying, at least as far as zoning is concerned, is not an issue. even if the events did occur, we're saying that they didn't occur in the way that the neighbors have alleged they occur, but even if they did occur, there's another reason why the decision is still erroneous. None of these events have changed the essential character of the property from residential to commercial, and I'll discuss that too. The fourth reason the decision is arbitrary and capricious, that's not your standard. You're making your own determination here. But if you uphold an arbitrary decision of your building commissioner, that would be grounds to reverse your decision on appeal. So I think it's important. It's arbitrary because he didn't conduct an independent investigation. It's arbitrary also for another reason. He seems to pull the number 7 out of a hat. 1 is okay. 7 is not okay, but he articulates no standard. Is the right number 5? Is the right number 10? He just says conclusory that you've gone too far without articulating any standard. It's the definition of arbitrary. And then most importantly, it's unenforceable in my opinion, and I'll talk about that too. Before I summarize our points though, I just want to address a couple of things that I heard from the letters that were read. And I appreciate the fire chief's concerns. I appreciate the Neshoba Health agent's concerns, and I appreciate the clarification that it was not the Board of Health. But respectfully, zoning is not the province of those officials. Where those officials' input is critically important, and we've had it, is in the licensing phase. The issues of public safety, health, welfare, all of those things were discussed with the Board of Selectmen in the context of the entertainment licenses. They were the subject of conversations with the building director, the land use director, I'm sorry. So those are all very important considerations, but in my opinion, those are licensing issues and not issues for this zoning board. But back to the issues that are for the zoning board. The burden shifting, it's clear that this is a problem, and I've cited some case law in my brief. The burden is clearly on the abutters to establish that the property owner is not using his property for a permitted use. The burden is never on the property owner to prove that he's using the land in compliance with the zoning, and the January 23rd letter from the zoning official that he refers to in his March 18th decision quite clearly, point blank, asked the owner to prove he's using his property in conformity with zoning. That's just not how it works. He has no burden. The burden is on the neighbors. The events, as I said, the evidence, had he conducted an investigation and talked to Dr. Massey about it, he would have learned that 6 of the events didn't happen. Some of the events were private events. I mean, he has a pond on the property. One of the events was to invite people ice skating on the pond. It just, because the facts were not found, his decision is unsupported. But even if you believe that those events happened, I think the nub of the argument here is that it's still not prohibited. It's just not possible to imagine that so few events on a 140-acre property over 365 days a year has somehow mystically transformed the primary residential use into a commercial use. And there's 2 different ways we can legally look at this. The law of incidental use looks at the property and the totality of the area and takes into account things like the size of the property. And what's ancillary to a 140-acre residence with a pond on it is not the same thing that's going to be ancillary to a condominium or a residence on half an acre. It's an analysis that's specific to the property, and it needs to take into account factors such as the size of the property. And when you consider the size and the accoutrements of the property, the uses that Dr. Massey is putting the property to, in our opinion, are incidental to the residential use and have not transformed it. The other way to look at it is the way that the building official seems to have looked at it in much more of an alchemy kind of fashion. He seems to think that at some point there's a tripping point where too much goes too far and you suddenly become commercial. He doesn't articulate what that is, and I think for that reason the decision is arbitrary. But let's look at it that way, and let's take their numbers. I think their numbers are grossly inflated, but let's look at 29 events over 4 years, the 7 events or so a year, and let's even say they were all 2-day events on average. That's going to be high because most of them were single-day events. There were only a couple of day events, but 14 days out of 365 is 4%. How anybody can say that, even if it all happened, how anybody can say that that transforms the residential use of this property, it just doesn't make sense. So either way you look at it, this is a residence. Dr. Massey is not running a business. If he has sold tickets for a couple of the events, it's been to get an idea of how many people are coming or to get contributions for some of the events, food or other things. I mean, it would be like I was having a backyard barbecue and asking my friends to chip in for the beer. He's not running a business. He's not trying to make money doing this. He has just not turn that into a commercial enterprise. And as I mentioned, the decision is arbitrary, and again, it's arbitrary because there was no investigation conducted and it's unsupported by the facts, but it's particularly arbitrary because he just makes up a number, and he provides no rational basis for the number 7, and in fact, really what he did was he backed into the number. He took their number and he said that's too much, and there's no analysis. And finally, we get to the enforceability of this, and this I think, I think this is critical, and I'm going to read from the opinion again. In conclusion, you are hereby ordered to cease and desist the use of 300 Holman Street for events that are prohibited under the zoning bylaw. I don't know what that means. I don't know. I mean, we have 3 proposed events that are currently licensed by the Board of Selectmen. One's an art exhibit with a lecture. The other 2 are related gay pride events, which feature a stage performance and also a lecture on, I think it's gender identity issues. It's not at all clear that those are even prohibited by this order. He's not telling the applicant what he can do or what he can't do, and constitutionally, you can't do that. You have to warn somebody about what it is they're not supposed to do. And even in the paragraph before, even his attempt to try to address those 3 events, all he says is, I understand that you are currently requesting additional entertainment licenses from the Board of Selectmen. In my opinion, it is my opinion that these events, if similar or equivalent to, not defined in any way, to those complained of, are prohibited. Again, it's vague, but even more than vague, as we've already discussed, some of the events in that list of 29 that he's referring to include constitutionally protected political assembly, and it's, in my opinion, if you tried to enforce this in court as it's written, you couldn't do it. The court would look at it and say, this is vague and it's void for vagueness. So at a minimum, what we'd like to see this board do is vacate the building commissioner's order and send it, if you can't promulgate your own, and I'll leave it to town council to tell you what the limits of what you can do and can't do, but send it back to him with some guidance as to what, in your opinion, conforms with the zoning bylaw, and give him something to work on so that somebody can finally answer the question that is plagued this board, the planning board, and the Board of Selectmen: what can a person do with their residential property? Thank you.
Mr. Bowen? Would you just stand there in case some of the board members have questions?
Sure.
With that, I'll open it up to the board to see if anyone has any questions of Attorney Bowen while he's got the mic. I just have a question. You mentioned sold tickets for events, and that this was just like a contribution. May I ask what events and what those prices were?
I'd have to ask Dr. Massey to come up here and give us the details.
Okay, all right.
Good evening. Dr. Darren Massey, 300 Holman Street. Thank you for hearing this, and thank you for your guidance, which I look forward to hearing. To answer your specific question, the primary event that sold tickets was the music festival, the 3-day, 4-day licensed music festival, Unifier. They sold tickets as a professional company. That was to provide for all the various services. It was a professional company. They sold tickets to pay for all the professional services, including services that the town provided to reimburse. That was the one primary service that sold tickets. It was a second event, a family group who wished to begin a band, 20-somethings. They wanted to invite their friends. The suggestion from myself, and they did go with it, was to model their beginning a band on, if you inverted commas, selling tickets. There wasn't physical hard copy tickets. It was only registering people for the number of names, who would be there, who wouldn't. And that was primarily for myself and my suggestion, so that I knew who was on the property. It was from a safety point of view, so I knew the names of the people who were there, the numbers of people who were there. It was an extended group who have a band, wanted to further promote their band, friends of mine that I know, and so I agreed to that. And that was the format. It was a registration, if you want to invert commas, of tickets, but it was basically people entering their names in a database that was collected online.
And what was the cost of the ticket, or the registration, or whatever?
It was by donation. That was to cover.
Okay, so there was no price. It was strictly donation.
It was strictly by donation, no minimum, no maximum. So the minimum was as long as I agreed for them to be on site.
Okay. You know how many guests at that?
There were about 80 roving people that day.
Okay. Okay, and you mentioned you have 3 proposed events coming up. Are these similar
Correct.
events?
There's members in the audience who could speak to those. The 3 events include, as mentioned, the first is a photography event. We've, in attempting to, just to back up for a second, if you don't mind, in attempting to use this beautiful property, very grateful that Sandra Lane chose to sell it to me. I wrote her a letter saying, look, I'm a guy, I believe in the arts, culture, conservation. You have this beautiful property. I wish to work alongside the town for them to purchase as much land as possible. They did. What was remaining, I wish to attempt to protect from building developments. And so there I came to the town. You mentioned the date of the purchase of the property. And for the last few years, attempting to find guidance, and this is, as Attorney Bowen says, the next step. And I'm really just honestly being here to figure out with the town in a good way, and the neighbors, or complainers, as some people call them, a good way to use this property so that it's not chopped up. and to do it in compliance with the law. So I have this property, the 3 proposed events that we've done, like that the Unify, approach the Board of Selectmen, approach all the people we've been asked to approach, give us some answers, give us some guidance to show what we can do, and then we can see, does it work? Do we need to pare it back? Do we need to increase it? So the 3 events that have been approved, the first is photography. We came to the Board of Selectmen, they approved, with provisions. I said, please give me your provisions. I'm all for provisions. I would love you to give me provisions. And they gave me the provisions for those 3 events, capped it at 250 people. The music festival was 500, and there were complaints for size and noise. They were proved to be unfounded by the chief of police. However, I said, give me a number, and we'll go with that number. And they said 250, so they gave the provision of 250. I said, thank you very much. We will go with 250, and let's see how it is. And so I'm looking forward to June 8th, the photography event, where we will cap it at 250 people, and we'll learn from there. We heard from one of the chiefs in a letter. He sent a representative to the meeting, where I've met with all the line departments, fire, say, Board of Health, police, conservation. And I said, please give me provisions. And so I'm in this bind where I met with the fire, and they gave me, there's no concerns, is what they told me at that meeting. We concur that this event could move forward, the photography event, to the Board of Selectmen, and that's what they wrote there. And now I'm hearing this letter in contradiction. So I attended those department line meetings. They gave me the contingencies. I agreed to them all. We went before the Board of Selectmen. They added a few more. I said, thank you very much for those contingencies. Number of people, 250 with the others. And now we have a permit for the photography event. I've agreed to meet with the complainers and the neighbors to continue to work, and they've declined. I've offered a mediator, several mediators, professors of communication from Fitchburg State. I've offered volunteers from Lunenburg to be mediators, well-respected people in town. They've declined. So here we are. So contingencies of people for the photography. Have a permit. I invite you to come to that event to see what the actual property looks like. I invite the building commissioner to come to the property. He's declined. I've invited the neighbors to come to the property. They've declined. I hope you choose to visit the property to see for yourself what this property actually looks like. Do the investigation. The second and third event, they're a combined event, the Pride Festival. Fitchburg is doing a Pride celebration in conjunction with Lunenburg. We sent grants, not myself per se, but we sent grants to the Lunenburg Cultural Council. They gave us some money. The Fitchburg Cultural Council gave us some money for the Pride Festival in Fitchburg. So the 2 permitted events in Lunenburg, same are a Friday night cookout bonfire. Just a cooking fire that the fire department approved in that department line meeting. So that's going to, again, capped at 250 people, Friday evening, cookout, where we have approval from the fire, we have approval from police, we have approval from the Board of Health, and approval from Conservation. And that, again, went to the Board of Selectmen, and they said, thank you, we approve with those contingencies. Thank you very much. And again, I invited them to come to the property to see. And then there's the Sunday event, which is the drag celebration and the talk on gender identity. I'm interested in the education side of things, so we have various Fitchburg State professors coming to give a speech and a talk and a discussion on culture and diversity. And again, I hope, again, under the provisions, less than 250 people, I hope that the neighbors attend to see and to guide me. I will continue to modify as fitting for the property, as fitting for the butters, as fitting for the legal requirements, as fitting for the culture of the town. It's just a waste to let this property go. That's the bottom line.
Okay, thank you. One thing you said is
Yes.
that the complaints were proven to be unfounded.
Oh, yes.
Can you tell me how they were proven to be unfounded?
There's various complaints, so they've been proven to be unfounded in various ways. Some of the complaints have gone to the town manager, and she's opined of their not being founded. Some of the complaints have gone through dispatch to the Department of Safety, and they've been investigated by police and fire, either by interview or the actual lieutenants have come to the land, either during, let's say, the Unifier event. There were multiple calls made. Various lieutenants came to the property. They investigated independently. They investigated with myself and other coordinators who were there, and they opined that they were unfounded. I have always, by the chief of police and always by the chief of fire, whenever there's been a complaint, I have always asked them if there was anything that was validated, and it has always been unfounded as regards those departments. If there has been anything, I have met with any of the commissions. I have attended, I don't know how many meetings by now, and I have always looked to, if I have ever made a mistake, to modify it where I have, so that I could modify and use the property in a way that works for most people and is within the law, obviously. So it's been through the chiefs, it's been through the town manager. And anything else that wishes to be investigated, I welcome explanation. By all means, please send me a list of questions and I will write you answers. By all means, please visit the property and I will show you around, or please visit the property independently. Either when there's not a so-called event, I was saying most of these events, 27 on the list are my friends. So either visit when there is a so-called event or one of these permanent events through the Board of Health, or visit independently when there's just regular living on the property, to make up your own mind, and to ask me more questions, verbally and in writing.
Does the board have any more questions? Anyone from the board have questions?
Not at this time.
Not at this time, Mr. Chairman.
Thank you.
Thank you. I think with that, Gary Rhodes, the building commissioner, is here, so I would invite him up to...
Thank you, Mr. Chairman, members of the board. I think it would be helpful if I did some background information about what has been transpiring in my mind.
Please.
Previously, Dr. Massey was in front of the board looking to get permission to do a camp, to run these type of operations. And at that hearing, I voiced objections, and the board gave Dr. Massey an opportunity to withdraw, and he did. After that, I asked for a meeting with Dr. Massey to sit down so I could get an understanding of what he wanted to do and try to get a better sense of what's happening out there. As a result of that meeting, I asked him, would you put everything in writing that you've done in the past and what's happening? And then we talked about one-time event. When he gave me this information, it was like a wedding for his family. There are events for his family and friends and stuff like that, close friends. And I accepted that as being, okay, it sounds reasonable that a residential property should be able to do that. We talked about a one-time event. What I try to do when I look at residential uses and what you can do on your property, I look at it in the scope of what's happening. If somebody wants to run a party at his house, a big party or an event like what he did, if it was an ongoing thing, I would have a problem with it. But when it's a one-time event, I didn't. I can think of a lot of different scenarios where one-time events happen. Yard sale. You have a yard sale in your property. Can you do it? Sure. If you asked me I said, yeah, not a problem. But if you start running yard sales every day and it goes on and on and on, it's no longer a yard sale that's customary within it. After that, I received a complaint back in October of last year, October 18th, from the neighbors. And the neighbors, you know, they were saying, well, he can't, he's doing all these things over there. He had something like 17 events held and stuff. But he didn't tell me what they had done. So I asked them, would you please just give me some documentation as to what you feel was so egregious that's been happening out there? And they did present me with a letter. And the board has that letter. And it shows a bunch of events that are being held out there that have been held. These events are not, I've been accused of not investigating. These are all listed on the website. So the information's open, and that's where these information the neighbors gave to me. Now, were every single one of those events an issue in my mind? No. You know, I think that one of them, in our meeting I had with Dr. Massey, said his son was having some friends over, I think from MIT, to do a robots thing. And I said, yeah, I mean, that's normal. They just put it on the website. So I know there's things that were ongoing. Now, it's also been alleged here that, you know, the neighbors don't have standing. I don't really think that that's an issue here, because the neighbors asked for me, as a town zoning enforcement officer, to take a look at it. They filed a complaint. I chose to do it, not the neighbors. I'm the one that issued the cease and desist, not the neighbors. If I had decided not to take action, then the neighbors had the right to appeal, and then maybe standing would be issued. But right now, I think as a zoning enforcement officer, I have standing to issue a cease and desist. It's a common knowledge. That's what my job is. So that's what we ended up with. Now, what we did recently is, when I started looking at it, I also came to my attention there were 3 more events that were being scheduled for this year. Fairly large groups of people are going to be there. And I looked at it in the context of not this one property, but should this be done anywhere within the town of Lunenburg? Can anybody, doesn't matter how large your property is, can that be anybody's property? Can you run that? Can your neighbor run it? Can they have massive amounts of people on your property and running what I consider a business? I don't think that's appropriate. But when I looked at it originally, I looked at it as one event. And I wrote a letter about one event. That mushroomed into a lot more. Maybe I was judged people that I thought it was okay to allow the first time. Maybe I shouldn't have. But I did what I felt was appropriate for that event. Now we come in, and I've been indicated that, you know, I didn't investigate it. I sent the letter and the complaint to Dr. Massey. I said, here's the letter that's being alleged against you. What do you feel? Is there something wrong about what's been said here? Is there something not appropriate? Did they mislead? Did they lie about what was there? Nothing. The only thing that came back in the letter, we think we're okay to do this. We think maybe it's an educational use or a conservation use. And when you look at the bylaw, I didn't feel it was either one of those. So I took my best judgment and said, I think you've gone beyond. You know, he says that I don't know, I'm not clear about events. Let me see. We have 3 events in front of the Board of Selectmen, and I don't know if I'm supposed to write each individual thing, but those were referenced in my letter. Those are the events I'm referring. I use what happens in the past and looked at combined with what's going forward. I can't order a cease and desist for events that are already passed. I can only deal with the things that are moving forward. And then I look at the history of what's going on out there, and I put it all together to try to create a package. And I have to use my judgment about what is appropriate in a residential. Our zoning bylaw doesn't say, well, you can have one event of whatever on a private property. It doesn't do that. What it does is it allows people to do normal residential activities at your house, a party, a wedding, you know, a group of people, of friends, a democratic conference at your house with a candidate, 100% appropriate. I'm not arguing that that is the issue here. The issue is what is happening in the next month. Right now, and I'm using the history of what has happened to look at what's going to happen. Now, one of the things I noticed that, you know, they've agreed to continue this. Now, I believe that if you go to your regular meeting, that's going to be after the next event that's scheduled. I would like to have a clear understanding from Dr. Massey. Is he moving forward with that event, with this hearing ongoing or not, when the board hasn't rendered a decision yet? And if it's so, then I may have to take action as seems appropriate. I can answer any questions for you.
Okay. Any questions from the board?
I just have one question, Mr. Chair. Your 7.5 number, which I think Attorney Bowen was also referring to, you're just kind of taking all the events that
Yeah.
you have kind of gotten information on and just,
And I just took the number and then divided it.
right, okay,
And that's all
over
it
that
was.
time. And when you talked about the one-day event, did you know about all these other events when that was going on? I'm assuming you're talking about Unifier?
Not,
For the-
because at the time I was new here. And what I did is I asked them to give me a written understanding of what's been going on. And that's where they came back with, well, it's a wedding for friends, it's this, it's that. And I felt they were very appropriate. You know, I'm not trying to be unreasonable. I thought what they were doing seemed to be okay. They assured me that, well, there wasn't any tickets, there wasn't any advertising, there wasn't, you know, all the things that you would normally expect if you thought it was a business. That wasn't what was happening, what was alleged to me. I didn't get a real good understanding until the neighbors submitted their documentation and along with all the stuff off of their website. You know, so, and that's all I have to go by. I have to realize, I mean, because I wasn't here.
Right.
You know, I can't jump back in time and figure out what was going on. I can only look with what was being provided.
Right. Okay. Thank you.
I have a question, Mr. Chairman, the
Please.
Commissioner. So I just want to be clear, from your understanding and your interpretation of the bylaw, these type of events, there's nothing in the bylaw that describes this type of event that they're having, is that correct? And
That
that
is correct.
therefore,
Well, actually, I think there is, in a way.
in the commercial district,
Exactly. What the bylaw talks about is outdoor entertainment. That's not allowed in a residential zoning district, and I feel that these have mushroomed or morphing into that type of a situation. I really think it's more of an outdoor entertainment aspects. I think it's more in line with indoor entertainment. I think that is more consistent, because the other aspect of Lunenburg zoning, which is very critical, if it isn't provided for, you can't do it.
not
You
permitted.
can't make up your own uses and say you should be able to do it.
I mean, I think your interpretation of, one-time events, with relative infrequency, not an issue. Hence,
I don't think it is.
why you said you could do it before. But when someone has 250 people there, not only friends, but people that they don't know, that to me sounds like it's a commercial enterprise. And I guess the question is, how do you interpret that with the fact that the applicant would like to make use of his property? And how do you work that out? But I just wanted to ask you that. And then the other question I had was, as you know, when we issue a special permit, there's certain findings that we have to identify before we do it. And I think part of that is, I think where the abutters come into play, the fact that, we have to be respectful of what their property rights are as well. But you're clear that it's not a permitted use because there's really not, the event perspective per se in the zoning bylaw is allowed in a commercial district, but not in a residential district.
That is correct, because I go back to my analogy about the yard sale.
Yep,
A yard sale is allowed. I think everything's cool about that.
yep.
But if you start doing it on a regular basis, that's not what, but the bylaw doesn't necessarily say that. What I do is I then say, well, this is really not a yard sale. What this is really an outdoor market. And you've changed. Now, when does that actually happen? Do I say 1 day? Do I say 2 days? I have to use a judgment. And that's where, I mean, unfortunately, I have to make those calls.
Sure. I mean, we rely on you to interpret the bylaw and help us, say what's allowed and what's not allowed.
And then afterwards, you have the right to look at that.
Sure.
My determinations, like what's happening here today.
And one other quick question, has the police chief weighed in on any of this stuff in terms of like safety with, I haven't been to the property, so I don't know what the property is. Maybe they could accommodate 250 people and no one would see them. I don't know. I haven't been down there. And I'm just curious from is one of the things, again, when something like that happens and you know, before this board, safety is a big issue. You know, is it safe? A, you know, has the police chief weighed in on that?
Under the zoning, the answer is no, because there's nothing within the zoning bylaw that gets me into asking him his
Okay.
opinion or his advice.
Yep.
But when you get to the entertainment license, he does provide comments to the Board of Selectmen for their preview to look at what might be needed in order to address that event.
So if they're coming before the selectmen for an entertainment license,
Yes.
that to me sounds like it's a commercial venue,
Yeah.
right? I mean, why else would they be asking for an entertainment license?
The one thing it's always kind of hard to put a firm grasp on is the Board of Selectmen are looking at it from one set of laws, the general laws, and they're looking at it with blinders on that says, is it appropriate site? Is there adequate safety? They're looking at it from a very blind. They don't look at it and say, well, Gary, can they do it? While they ask, and I say, no, they can't, they aren't really able to look at that aspect of it, because as zoning enforcement, I'm sitting over here with a separate law, and I'm the only one that can make that call initially, is the building commissioner. So I'm over here making that. The selectmen don't have any say over that,
Right.
whether I say or don't. At that point, we have two different things. We find it's not necessarily great, but that municipal government is full of these type of things, where one board is going to say one thing and another board says no, and that you have to bring them both together for the applicant to make sure that it can happen. I'll give you a good example right now, and this killed me. We just passed a new building code, and the building laws have changed. That you realize that if you approach me and say, I want a building permit to build a house, I will look at it and say, do you meet zoning? And because that's under my purview, I'm the person. But I don't care whether you have a septic system, because I have no jurisdiction. I have to issue a building permit on a house that doesn't have a septic system. And the problem is that becomes the Board of Health's worry. We separate out the two. They're making more and more as to who has jurisdiction to do what. And government there are a bunch of houses in this government, and not every one of them, they're going to say yes here, no here. The person at the top wanting it has to make sure they all come together. They can't just pick and choose and say, oh, I got this, I don't have to worry. That's what happens with the Board of Selectmen and their entertainment license, and why it's appropriate for the fire chief and police chief, well, more so the police chief, to make comments to the Board of Selectmen for their entertainment license while they consider that.
Okay. Thank you. Thank you, Mr. Chairman.
Jim? Question?
Yes, you said something about wanting a clear understanding about the next event. If we are not able to make a decision tonight, per se, could you elaborate on that a little bit more?
Right now, there's a cease and desist on this property for all three of these events coming up. That's been appealed. And the next event that's going to be held is, I believe, June 8th. And I believe the Board of Appeals' next scheduled meeting is the 12th.
I believe it is June 12th.
So we have an event that, without the board having decided one way or the other, and I think it's important, I would like to know from Dr. Massey whether he's going to attempt to hold that event, well, this is still outstanding or not. And then I can decide as the building official what action I would take at that point. I think I'd rather not, it's premature for me to say what I'm going to do, but it would be very helpful to understand what they're doing going forward.
Okay.
Thank you.
So, as I'm listening to you, I think what you're trying to figure out, when does it go from residential to non-residential, commercial? And you're basing your opinion on the series of events and the number of events.
I'm looking at the history, the type of events that have been held, and I look at, are they appropriate in a residential area? Are they more than a one-time event type of thing? And what I'm finding is, in my opinion, it has gone beyond that one event that I said was okay. You know, there's been attempts to have dog sleds out racing out there, and there's these 3 events this year, and there's been other events in the past for which, while licensing should have been a plane, they weren't. It's sort of like it's gotten, you know, it's just morphined off from what was originally approached to me.
Okay. And as the building commissioner, this falls into your lap. You have to make this decision.
Yes, yes. And I wish there was something clear, but there's so many variables and there's so many possibilities that you have to look at each as a case evolves. It's just like I say with that yard sale. When does a yard sale become an operation? And there's nothing that's going to tell me other than I have to look at what is the history and what seems to be going on, and I use my best judgment. And when somebody disagrees with me, that's when it comes to you guys. And you're the one that sees whether have I been reasonable, am I overstepping? That's where you are.
Okay. Any other questions?
Yeah, I have one more question, Mr. Chairman. So, would it be fair to say that the applicant has been willing to work with you or willing to work with the planning director or the planning board in terms of trying to rectify some sort of classification, I guess, under the bylaw, or like, for instance, at the town meeting where they had something proposed and then they withdrew it? I mean, is that a fair statement to say that the applicant's been willing to work with the town?
I'm probably the wrong person to ask. The reason being is I don't work for the planning board.
Yep. No, I know.
And I'm not privy to their discussion between the town planner, land use director, and the board. I'm kind of on the outside, and maybe at lunch someday we say, hey, what happened, type of thing. So I can't judge that, hey, there's been a great relationship to it. I can tell you that when we initially met back in 2017, you know, I said that I felt what they were proposing didn't work. And that pretty was what I would say was the end of my job. But what I try to do is encourage them to say, look, the planning board is the people that may change it if it's appropriate. I'm not saying just because you ask, you get.
Yep.
But they can look at it and consider whether or not it's appropriate for not just this property, because that's spot zoning, you can't do that. But is it appropriate for the entire town? Is that right for every property in the residential districts to do this?
And then, Mr. Chairman, one last question. So are you aware, since you've been in town and your experience as the building inspector, have you had any other applications like this where you've had to make this determination? So like-kind instances?
One of the most recent ones, like the Stillman Fair.
Yep.
The fair they held at the
Yep.
Stillman and stuff like that. I looked at that, but what I decided with that one, Stillman's is a agricultural use, it's a farm.
Yep.
They have a real big, broad ability to do things that are not just milk cows.
Sure.
And I looked at this as being an event that maybe, if it stood by itself, was not a right, but it's a right, it's appropriate for a farm to promote itself in this manner. So I have made those kind of determinations with that.
And that was similar to what you did on the one-day event when you okayed this event to happen in the past and said, okay, you know, we'll give you the one-day event. So, I mean, you were being fair to them and you're fair to the Stillmans.
I felt that I was. And like I say, I made it clear when I did the first time, I said, you got to change the zoning. This is not going to work as a use out there. I don't feel it's a right thing for residential properties.
Got it. Okay. Thank you, Mr. Chairman.
You're welcome.
Also was mentioned earlier that there's another application for a permit on a 9-acre lot a few miles away. Are you aware of that? Or I think Mr. Bowen mentioned that in his beginning remarks.
It doesn't ring a bell off the top of my head. I wasn't thinking about this.
Could I ask Mr. Bowen if he would,
I'll let him answer that.
could you clarify that? Or if you don't
At-
mind,
at-
please?
At the last, well, not the most recent Board of Selectmen's meeting, but at the last, I think it was at the last Board of Selectmen's meeting prior to the election, a resident on Howard Street, I don't have the resident's name, I don't have the property address, I think she said her parcel was 9 acres. She sought an entertainment license and received an entertainment license from the Board of Selectmen for a 3-day event featuring amplified music, amplified sound, some of the same things that these complainers are here complaining about, less than a mile away from where they're complaining about this applicant, and that was passed without fanfare, with a little tweak of the hours, and not a great deal of discussion by the Board of Selectmen. And I don't know if the building commissioner has an opinion on it.
Thank you.
Well, he said he hasn't heard of it at this point, so I don't know if he has
I'm
an
not-
opinion.
Yeah, I'm not aware of it, so I really can't comment on it.
I'm not aware of it.
If it's,
either at
this
this time.
this hearing's continued, it seems like it will be, then I can check in to see what it's about.
Could we ask Mr. Alonso if he is,
I don't think so at this point.
Okay.
Because I don't think, the commissioner says he hasn't heard of it.
thank you.
And even what Mr. Bowen said, he didn't know who, he didn't know where, he didn't know a name. So I think it's premature.
Thank you.
And just one comment, the complainant's complaining of the neighbors with issues. So you had said that the complainers are complaining? I'm just straightening it out, that those are neighbors that have some issues about the events. Any other questions from the board?
Not this time, thank you.
With that, I'll open it up to the public. If anybody would like to speak, please just raise your hand, come forward, say whatever you would like. Please.
Name and address.
Could I have your name and address, please?
Yes, good evening, John Dombrowski, 6 Grove Avenue, Leominster, Massachusetts. I'm an attorney that was retained by a lot of these neighbors that are concerned. I'd suggest to the board respectfully that I believe the building commissioner has, handled this very appropriately and probably more than fairly. My clients are homeowners, they're taxpayers. Like most people who own a home, their home is their primary asset. And they're located in a residential zone. It's a protective bylaw. One thing I'd like to bring up is I believe the subject property is very large, but Holman Street is essentially a dead-end road because of the bridge. The bridge is no longer functioning. And my understanding is the petitioner's property is located at the end of this dead-end road. And most of those activities, although it is such a large property, most of those activities are taking place in that area of the dead-end road. But, having said that, this really isn't as complicated as the petitioners are trying to make it appear. It's really about common sense, isn't it? If you own a property in a residential neighborhood that's zoned residential, there's an expectation that your neighbor's daughter might get married, and she might have a wedding in the backyard. And there's an expectation that there's going to be a cookout. There might be a Labor Day cookout. There may be a party on July 4th. these are reasonable expectations. There's an anticipation that somebody might host a fundraiser for a political candidate or a meet and greet. But to have it occur with the regularity and with the volume in the expectation that it's going to occur, we're going to keep doing this. In this neighborhood, it's just not appropriate. The events are wonderful. The arts, what they're trying to promote, these are all noble ideas. They're great. It's just the wrong forum. It's just the wrong place. There's a big tract there. You know, there's something that's going to be done before another board with the change of zoning or different frontage on I think it's Route 13, you know, I don't know, then so be it, have at it. But to put the burden on these neighbors, I mean, think about it, a 4-day musical event where tickets are sold. It's almost mind-blowing. We're going to have 3 events, and we're going to cap them at 250 people. The only other thing I'd like to add is the license that were granted by the Board of Selectmen have been appealed to the court. I don't know if this board is aware of that or not, but they were appealed to Worcester Superior Court on a writ of certiorari by these neighbors. You know, that's something that's being taken up as well. But I just suggest that the building commissioner has done his homework, and his approach has been more than reasonable, and respectfully ask that this board uphold his decision. Thank you very much.
Thank you, Mr. Dombrowski. Would anybody else like to speak? Anybody from the public? Please. Yeah.
My name's Nate Wallach. I live at 6 Windermere Drive. I'm in a butter. I share a property line.
They say you can't hear, but just...
My name is Nate Wallach. Is that better?
That's better.
Okay. All right. I live at 6 Windermere Drive. I'm in a butter. And I bought our property about 2 years ago. This is our second house in town. We were moving up, okay? We went from about 1,800 square feet to about 3,000. Okay, we got a nice, beautiful piece of property. Only to find out that this is going on in the woods behind me. Okay? This psychology doctor is a manipulator by nature. Okay? That's what he does for a living. Okay? He's smarter than all of us. And he's convinced that he can come down here and that the laws don't apply to this guy. He can come down and change them to do whatever he wants. And, you know, I'll tell you what, I waited 8 hours down there at the town hall meeting to talk, and he, of course, conveniently pulled his articles right at the end there. And I really appreciate him taking up my Saturday. So I got quite a bit to say here. Mr. Massey now thinks the town bonfire is going to happen on his property. Okay? This was a recent announcement with the endorsement of the fire department, of course. Okay? Now, this man is out of his mind. My wife posted, okay, that the Lunenburg's fire department's denial, okay, of this. And of course, this was pulled off of his site right away because we don't want that. Okay? He's tried to get himself elected to town committee to further his commercial agenda. Okay? He's used his buddies on the planning board to fix the game and put these articles in front of the town meeting. Okay? This is the definition of a good old boy network. And this is not Lunan Bama. Okay? I own copyright to that, by the way. I'm printing t-shirts. We have to follow the rules and be good neighbors. Okay, what these guys are proposing, they want to change the laws around, and these laws just serve one self-righteous person. Okay, this manipulator. Okay, no member of our neighborhood is in support of this sweeping, rezoning proposal. Anything that this guy wants to do back there, none of us are in support of it. Okay, and we're all down here today to fight. Okay, and you need to decide, Doc, what kind of tab you want to rack up. Okay? I'm serious.
To the board.
We've now hired legal counsel. You've hired legal counsel. We're going to win, and you're going to wind up paying. Now, the question is, how much do you want to pay, my friend? We're on the
Again,
clock
to
now.
the board, please.
And that's all I have to say. Thank you.
Thank you very much. Okay, would anybody else like to speak? Please, lady over here. We'll let everybody speak, anybody who wants to.
Good evening. Glad to spend my evening with you. This is Kathleen Winook. I'm at 503 Holman Street. I'm not going to rehash the stuff in the past because it's been, there's no point. What I see is Mr. Massey has a habit of organizing things already, posting them online, and then afterward going and saying, oh, I need a permit. In the meantime, it's already online, tickets are already being sold, because that's exactly what happened with the 3 events that are happening this summer. He got approvals, he worked with the outside organization for the Gay Pride events, and he organized it first, then went to you guys. And right now, like Nate just said, he posted today that he is having the town bonfire at his place, and he was thanking, everyone for giving him a speedy approval. He later had to go back and revise that post because I think the fire department also posted they heard something was going on and they didn't have any approval. So you need to be cautious with this man. He seems to have the town at heart, but you're not going to make any money out of him, and he's just going to get his business going. I was here when this started, when he first wanted to open his camp that would have, I think it was 200 parking places, 250 to 300 people staying there. He wanted to open a business. And he was told, no, you can't do this, come back. He was told to withdraw. And in spite of that, he continues to have events regardless. So you're all great people. Yeah, I appreciate you're here and listening to us, but please note, we're not crazy neighbors. We like our neighborhood. We like the quiet, we like the peace. We'll have parties, we're fun people, but we don't need to have this happening on a regular basis. Thank you.
Thank you. Okay, anyone else? I know somebody had their hand. Yeah, man in the, yeah, right ahead.
Hi, my name is Andrew Paradise, and I grew up in this town. I'm not a close neighbor of Holman Street, but when I was a kid, I did deliver newspapers there. I'm a Blue Knight, graduated in 1986. Bez was my physics teacher. So I've been a lifelong resident of this town. And someone here mentioned earlier the term peace and quiet. I've worked for 12 years as an engineer at Bose, and I can tell you that we've made an industry out of peace and quiet. They go together. It's no real surprise. Like I said, I'm not in a butter. I'm not emotionally attached to the situation, but I can tell you, if you take away someone's quiet, you take in their residence, you take away their peace. This is not something that should be taken lightly. One of the other town residents mentioned that they had bought property, and that was a great investment for them. And the feeling of being trapped in a place where you no longer want to live, where you feel like your property value has been diminished, where you feel like you no longer have peace and quiet, that's pretty tough. Now, the zoning laws There's a bunch of them, and it's your job to kind of adjudicate, interpret them, and that type of thing. But basically, their principle, the reason for them existing in the first place, is to protect the residents, is to be able to establish commercial districts. We all need businesses, we all need jobs, but we all need our peace and quiet. And it's important that those things are separated for the benefit of the residents. And I hope you take that into consideration. And I know maybe it's not a technical, legal aspect where you say, oh, well, this law is this and this law is that. But I can tell you that when there are outdoor events and there is amplified music, that stuff can rub you the wrong way if it persists. If it happens one day, if it's a wedding for a neighbor, right? Well, great, congratulations. Bring them a bottle of champagne, wish them a happy life, right? But when it's for a bunch of people that nobody really knows, what are we doing? What value does that have to the town, to those residents that have to endure this? So take that into consideration. And the last thing, like I said, I worked at Bose for years, and I happen to be an expert in acoustics. And I could tell you that there are state laws about volume control, so on and so forth. There are state laws about acoustic levels that are legal at a property line, and there are acoustic levels that are known to cause certain levels of damage, and they're not great levels either. If you're interested, I have the technology to measure that, to show what level is required to meet that, and the kind of acoustic protection that's required to meet those requirements is significant. Outdoor amphitheaters oftentimes will build 20 or 30-foot walls to deflect sound. Highways that go through residential areas oftentimes are required to build acoustic barriers. It's all for the protection of the residents. So I want to thank you for listening.
Thank you. Okay, I saw a few more hands.
I'm Helen Obermeyer Simmons. I live at 323 Northfield Road, which is about a mile from the property. And I am scheduled to be a speaker at the June 8th event. I'm a former professor of graphic design and photography at Fitchburg State. And so I have been researching the Lane collection that is in the Museum of Fine Arts, which is, it's really world-renowned. And so one of the reasons why Darren mentioned that he had written to Mrs. Lane when he wanted to purchase the property. And so one of the things we hope to do at the June 8th event, which I might add is an indoor event. There is no acoustics involved. It's just giving talks and lectures and looking at pictures on the walls inside. And so if you take that into consideration, part of the thing the woman mentioned that things were announced in terms of planning. Well, when you're trying to plan an event, you do have to promote it and you do have to let people know about it. And I was under the impression that he had the Board of Selectmen's, the special permit, and so I guess I did not know that there was some question about it being allowed or not. I agree that it would be good to know whether or not we are going to be able to hold this indoor event. The other thing I would say is, since it's only in 2 weeks, correct? And so I don't expect we're going to get 250 people there. Perhaps we'll get 50. But I just wanted to mention that this particular photography event is educational purposes only. I think there's going to be some, refreshments and things like that. It's not a ticketed event. There is no charge. And what we're trying to do is to really spread the concept of how important this property is and how important the Lane family was to Lunenburg and Lunenburg's reputation.
Okay, thank you. Anybody else? Please.
Good evening. My name's Eric Short. I live on 502 Holman Street. I'm at the end of the road on Chase Road. I'm here tonight. My passion with this is really for my neighbors that are the abutters. It was said by their attorney earlier, Mr. Massey's attorney, that the claims of the unifier were unfounded. I think Mr. Even Massey spoke to that. It wasn't as bad for me because I'm at the end of the road, but for a residential zone, it was completely ridiculous. It was music to the extreme. I even talked to Mr. Massey at the event. He has tried to work things out. He asked, what can we do? My comments to him were, you can't have events with 500 people at your house for 4 days with people camping next to your butters. And if it was just 1 or 2 events, small thing, the event like the woman just spoke about, I don't think people would be having a problem. But it's not. He's got 3 events planned today. He launched a campaign this afternoon before this event, which in my mind is crazy considering we were having this meeting tonight, that he's gonna have the town bonfire on his property. I mean, it's just not gonna stop. And I'm not a person, it's his land, he can do things. If he wants to have, like the commissioner said, or the building commissioner said, I think he spoke very intelligently. If you wanna have a wedding, if you wanna have a party, there is no one, these are all great neighbors. I have some parties, they have parties, no one is arguing that. To have 250 people, 500 people, where does it stop? He's also trying to change the zoning. His long-term plan is to change the zoning so it's a commercial use. And as suggested, that's probably his only avenue to perform these things. And that may or may not happen, but that's not up to this board to decide at this point. I just think it's a long series of events. It's not going to stop. It's evident it's not just hearsay, it's on his website. His home is called the Tenderness Gathering. It's not 300 Holman Street it has a business name as far as I'm concerned. It's just one event after another. He's pushing. The long-term goal is a commercial property. As he says, it's a beautiful property, but it's a residential property. My parents luckily own a beautiful property in the Adirondacks. Mr. Massey would be amazed at the beauty on the water. They would not be allowed to hold these commercial events. It's residentially zoned. It's not going to change. It's in the Adirondack Park. Those are the rules. That's how we have to live by. Eventually, I'll get the property. That's not going to change. It's not any different for 300 Holman Street. It's a residential property, and he has to abide by the same rules that everybody else in the town abides by. And unless that changes, I think we're spinning wheels up here. And again, it's not a 1, a 2, or 3-time event. You can, argue about the different events, but it's 20 plus in 3 years. 20 plus. I don't know the data, but I'd like to see how many people have applied for that many types of entertainment licenses in the town of Lunenburg. My guess is not many. So I appreciate your time and effort. Thank you.
Thank you, Mr. Short. Please.
Hi, my name is Jessica Frank. I live at 278 Holman Street. I'm on the other side of the bridge, so I'm not quite as affected. However, I am affected. I just want to bring up that the property was purchased with the full understanding with the zoning that this is residential. It was not purchased with that he would use it for quiet enjoyment like everybody else in town. The petition for zoning changes one of for property located in distinctly residential and non-commercial area of town with no opportunity for additional commercial enterprise development in the area, and no plan within the town's master plan for development other than residential use. Any change in zoning would be for one resident and one resident only. There is sufficient zone land elsewhere in town to support these events and activities that he would like to have. It's residential. I'll bring up, my children live here. It's one thing if someone has a party, generally you know all the people that are there. When you're bringing in 250, 500 people that no one knows who they are, and a bunch of us have children that are there, we found people urinating on our property from the Unifier Festival. That's disgusting. That is not okay. And it's just not zoned. And everybody keeps bringing up the 240 acres or whatever it is. It's still residential. I live on 3 acres. So what? The acreage and the beauty of it, I agree with it. I love the art stuff. I'm not against it. But it's residential. And the size of the property really should have no bearing on whether or not that this is residential or not. I could buy 500 acres. It's still residential. My 3 acres is residential. No one would put up with me having these people there all the time. And yes, 4% of the time, it's easy to say, but I don't want this happening anywhere. Everybody, it's the other side keeps bringing up that the residents and the complainers, but I don't want this to happen anywhere. And the Howard Street thing that was brought up, I'm not in a butter, so I don't get a message. I would be happy to show up for that hearing as well. Because it's not just this event. This is setting a precedent that other events can, if this goes through, continues to go through with these even 4 events a year, let's say, or 3 events, 2 events, whatever, that's a precedent that we're setting elsewhere that anybody can decide to have these huge events. And anything with a ticket when they're strangers is not a private event. And for the photography thing, which I think the Lane property I've known about, it's amazing. However, you want to tell me your 250 people are allowed to come and they're all going to be inside that house? I'm fairly certain, I've seen the house, I see the house, I don't think 250 people could fit inside that house. I think 50 people would be pushing it to fit inside a house if you're using, unless everyone's going to be in bedrooms and whatnot. So, saying it's going to be inside the house is interesting. And last thing, addressing the fact that the complaints were unfounded. We called the police many times. The noise ordinance we were told it would be gone off by 11. It was after midnight. It was still on. It was miserable to live with. And we had to keep our children inside because it was so loud. And the safety. I live in a residential area. There's plenty of commercial land to purchase. If this is what he wants to do, please do it. Lunenburg could use arts, it's great, but please do it on a commercial land and protect Holman Street and everywhere in this town, not just Holman Street. That's what I think is important too. This is a precedent for the whole town, not just Holman Street and the abutters.
Thank you. Please.
Hi, good night. Anna Lockwood, 91 Main Street. I want to build on what the previous speaker talked about, creating precedent. Because when I saw the letter that the building inspector wrote to Mr. Massey, giving him a cease and desist letter, saying you can't do anything in your property, the first thing that I thought was, I do all this stuff in my property. And, he listed, having a garden club over. Well, I have book club over. Do I need a permit for that? Inviting a school over. Turkey Hill Middle School comes over to my backyard and they explore the pond. And, having an elected official over. I have had Jen Benson over my house, and we have had other people there. So, and also on the building commissioner's letter, he said, am I recalling you listed 3 or 4 events?
Please address the board.
I don't recall the number of events that he counted to say this is passing a threshold, but these are the type of events that he was listing as being prohibited or needed a permit. And I'm worried that because of these, a very vocal group of people are creating a precedent for all of us residents in Lunenburg. Beyond anything, I pay my taxes, and I want to, as a homeowner, I want to be allowed to do whatever I want in my property. I have had birthday parties for friends in my house. I didn't know who they were inviting. I have held, there was a wedding of a friend of mine who came, she needed a space, and I didn't know who she was inviting. All those things are things that we do at a home normally, and creating a precedent that we can't or we need a permit is regulating too much, to a point of regulating free speech through zoning. That's just not, okay. And that's what it feels like. And people are talking about the unifier being, this being a continuation of a unifier. The unifier was 2 years ago. Darren's neighbors have been taking notes on him since 2014. And that's clear on the letter that the building commissioner sent to Darren, which his neighbors had listed events, how many cars were there since 2014. Now, can you imagine as a neighbor having people taking notes of how many cars in your driveway, who's there, doing what? It's really crossing the board of what is okay to be complaining about your neighbor or not. Now, so that's one precedent. The other thing is about the special permit. I do think that the selectmen needs to come up with a better plan of how to regulate that better. Because right now, currently the way it's written, they need to, there's not a lot of parameters of when to issue one or not. And currently the way it's written, they don't have to request permission or opinion from the building commissioner. That's why there is another permit for an event of similar to what the unifier was, that the building commissioner was not requested an opinion. Usually when the selectman offers those permits, they usually say, you gotta get the clear from the police department, you gotta get the clear from the health department. Within all those clears, there is never from the building commissioner. That's because it's not part of the process there. So that is a separate issue right there. It's not something that really belongs here. It belongs to the selectmen to make those rules. So if the selectman wants to add that they wanted to get permission from the building commissioner, go for it. But that's not how it is right now. And the reason there is this special license is because it's not zoned that way. The same way that St. Boniface is not zoned to sell alcohol, but they go and they get a permit for it. And that's just, so putting mixing in another thing into this process, it's just not fair. So it feels like we're getting all these things and just bundling it up, and bringing here and saying, hey, Zoning Board of Appeal, please take care of all this. And there's certain things that just don't belong here. St. Boniface right now, I think they have had an offer or a drive to hold masses in people's private homes. It's a great thing, Do they need a special permit for that? But again, that goes into the selectmen. Do we need to get a request from the building commissioner for that? And so there are 3 different things here that need to be looked at it. And I think that there's just too much going on, and I hope that you all, are able to see the consequences of regulating this many things. And another previous speaker said, we're not crazy people. And that was right after another previous resident was here threatening legal action. Please go, see how much money you want to, rack up on your bill. That's not very normal behavior. Taking notes on your neighbors since 2014, that's not very normal behavior either. So anyway, so I hope you all can break this apart, understand what is really in front of you, which I think is the cease and desist letter only. The selectman has the power to address the special permit. And yes, I do agree that they need to create better rules about that. Thank you.
Thank you. Anybody else? Please. Yes.
My name is Harold Allison. First off, let me express my condolences to the loss of a member. and also express my thanks and appreciation for each of you here today. I have observed from where I sat, each of you have been very attentive, keeping eye contact with the speakers and listening and making notes about whatever is being said. I came to Lunenburg in 1969. I purchased a 100-acre farm at 305 Flat Hill Road in Lunenburg. That has been my permanent home address ever since. Unfortunately, I'm also old, senile, and at the time apparently stupid. I divorced my son's mother some years ago. Since then, my home has been in Boston, Massachusetts. I recently sold that, and those funds have purchased a new home in Lunenburg with my son. Unfortunately, there is a restraining order against me, so I am a homeless United States Air Force veteran. Also, before I forget it, my thanks and appreciation for each of you who have spoken here today. You, sir, spoke eloquently about the responsibilities of your office. And you spoke eloquently about the fact that some people don't know is that it is the responsibility of the accuser, not the accused, the responsibility of the accused person to defend themselves. If I may, I have some words to express, but my memory is shorter than my hair on my bald head. May I be permitted to read some of these?
You may.
Thank you, sir. My reason for this letter is to share with you that our small community has shown exemplary community spirit and brotherly and sisterly love to our fellow community members. Recently, one of our excellent local farmers, Kimball McMillan and family, named Cherry Hill Farm, experienced a catastrophe. One of 3 cement silos had collapsed and crushed part of the barn. The families received support from church members, local farmers, some of whom have provided homes for their livestock, owners of construction businesses who provided equipment to begin removing rubble and figuring what can be saved. State and local agriculture officials looking to see what they can do to help. The residents who have donated money, so much food, and that the family has had to turn some of that away. I am so proud of our local police personnel, fire department personnel, town officials. I am so proud of our local town and surrounding communities, people and businesses that have demonstrated the God-given brotherly love of our neighbors. The USA is governed by a Constitution. The U.S. Constitution established America's national government and fundamental laws, guaranteeing certain basic rights for its citizens. You have demonstrated part of the laws of this particular community. There are rules and regulations. The rules and regulations must be followed. Recently, at one of the town meetings, I spoke in support of a 25-mile-per-hour speed limit at residential areas. Sometime after that, I spoke with Lieutenant Luth of the local police department. My understanding of his response was that the reasonable and proper speed limit for residential property is 25 miles per hour. I have not personally observed a 25-mile-per-hour speed limit sign in the town of Lunenburg. However, the understanding of the definition of a residential area is any place there are less than 100 feet or less than distance between the driveways for those residents. on Holman Street from Chase Road, Route 13, to the last driveway before 300 Holman, there are less than 100 feet between each of those driveways. My personal observation is that some, not all, some of the residents on that area do not speed 25 miles or less. Holman Street from Route 13, Chase Road, is so narrow that two vehicles have a very difficult time to pass at the same time. Most of the time, other neighbors, and including me, will pull over and let the other vehicle pass. Some of the neighbors, as other neighbors or other people have spoken, have multiple events at their own locations. And some of those have had anywhere from 4 to 10 vehicles parked on Holman Street, which means that wherever those vehicles had been parked, other vehicles had a very difficult time to get by. I'm not complaining, it's just an observation. Some time ago, there was an anonymous letter about a cult being at 300 Holman. The failed presidential candidate, Hillary Clinton, is quoted as referring to all those people who did not vote for her as a basket of deplorables. That includes 62,985,106 people who voted for our president, Donald Trump. I personally happen to be in that basket of deplorables. Additionally, the mainstream media, for fake news, has referred to those people as a cult. I am a proud member of the cult of the basket of deplorables. There is a thing that is rarely mentioned in our, not in our Constitution, but outside of our Constitution, that is liberty. Part of liberty is being able to do what you want to do with your own property. However, I can't do what I want to do with my own property. I have to go before the zoning laws. I have to go before the board, all of the other organizations in the town. They have the responsibility, and those are usually elected or appointed individuals to determine what the circumstances should be in this community. And I personally applaud each and every one of you for your excellence and for all of your work, for everything that you do on a daily basis. Much appreciated. My apologies for being old and senile. I forgot what else I was going to say. Thank you very much.
Thank you.
Do you have any questions?
Any question?
No.
Okay. No, we're all set. Thank you. Is there anybody else that would like to speak? Please, you'll be next.
Good evening, gentlemen. Tom Alonzo, 284 Lancaster Avenue, and I too, having known Paul, want to wish my condolences to you as his colleagues and to his family and friends. It was quite a surprise about his loss.
Yes, thank you.
It was a pleasure working with him. I come before the board in this hearing today because I concur with Mr. Massey's attorney on the ruling by the building commissioner in being arbitrary and not setting standards. Unlike what others have said, I don't think this is a slam dunk case. It certainly involves components of common sense, but it involves components of fairness and components of establishing, and I think that's what people look for, establishing clear guidelines about what is and isn't allowed. Unlike Supreme Court rulings about pornography that I can't define it, but I'll know it when I see it, hopefully zoning can get a little bit better than that, and we can define at least some basic parameters about how we're making the determination. And I think that the building commissioner's ruling, although I have nothing against the building commissioner per se, just the ruling, I don't think rises to that. Some things were talked about when he was up here, that he considered that the applicant, or the defendant, or the property owner, whatever you want to call them in this hearing, was running what I consider a business, but again, gave no determination by what constitutes any business. Generally speaking, we would, in a layperson's definition, would consider something making money or promoting one single thing may be a business. If Mr. Massey is doing that, he's doing a very bad job, since he doesn't make money doing what he's doing, and he's promoting various things, not one particular cause. So he allows his property to be used by people who have the need, and he feels he has the property and the size of property to work with. There was the indication that a yard sale once is okay, but if you had it every weekend is not okay. Well, there's one a weekend and 52. What's the number in between? Can we get any guidance by how many? And I think that's what Mr. Attorney Bowen had asked in the beginning, and also asked in his letter that the chair read, which is we'd like some guidance about what that is. It's between 1 and 52, maybe it's between 1 and 7, according to the building commissioner. But again, it should have some kind of standard. There was the indication that the size of the property shouldn't be an issue. I have a serious problem with that, because I think if part of what I understand the complaints of the neighbors is a disruption of what somebody called peace and quiet, and I can certainly understand that as a property owner. Well, if you're having 200 people over on 140 acres, it's a whole lot different than having 200 people over on 1 acre, if you have people all around you. So I think that the size of the property does play a part. Not solely, but certainly a component of the part. As far as determining the 29 events with no investigation, but he said that the events are on the website. I will bring your attention, or re-bring your attention, to what other people have come before you tonight and said, is that Dr. Massey posted today that he's going to hold a bonfire. Okay? Just because he posts it doesn't make it so. If he doesn't take it down and somebody looks back and a year from now says, look, you had this. It says here that you had this. Just because you see it on the internet, just because it's posted. If I said I went bowling last night, if nobody saw me there, did I really? So I don't think that's a complete identification of the property, the events that were there. And I think we'd have to go a little bit deeper than that in doing that. Some other comments said it's the number of people, but especially, I think it came from one of the board members, that it's not just the number of people, but it's the fact that they're people that you didn't know. So I would ask, okay, I grew up in a large Italian family on Long Island, and we had big family events on a half an acre in the summer almost every weekend. We had 40 to 50 people in our backyard every weekend, and they were all family. So if that was relocated here, would that be a breach of residential use? Let's extend it. Let's say it's not family. Let's say it's friends. Does that constitute a breach of zoning? If I'm a member of an organization, I'm a member of, a soccer club, I'm a member of a snowmobile club, and I have events in the summer or events in the winter, how many? Those are private. I know everybody there. They're all in a club. If I have a member of an organization that's an online organization and I invite people over and they bring a guest, is that? I mean, we need some determination, and I think the ruling doesn't give that kind of guidance. One of the things I also considered was if there were no complaints. So presumably zoning, you either are in compliance with zoning or you're not in compliance with zoning. So if nobody in the neighborhood complained, but yet the building commissioner, through some other method, determined that, you know what, this person is having 29 things, but the neighbors weren't complaining, would he still have issued a cease and desist? Because clearly, by his own determination today, under the same circumstances, devoid of the complaint, would you issue a cease and desist on that person? Because I think what's going on at that location doesn't have to do with zoning, it has to do with a neighborhood conflict that should be resolved other ways, and there are other means, I think, to do it. For instance, most of the people tonight who complained, who issued some kind of complaint about past events, talked about the unifier. The unifier was approved on the last year of my previous term in 2017. And I made a point, and you can go back to the video, I made a point to the board then, I'm like, we don't have any special event, multi-day event guidelines for this town, and that's what's being asked. Okay, what we need to do is concentrate on multi-day events, because I certainly have a problem as a homeowner of having people sleep over and having multiple days of music and strangers, and they're camping out even at night. It's not a 9 to 3 in the afternoon. It's not 3 to 7 at night on a summer's night where everybody can see and then everybody goes home. I think those are fine. And that hasn't been addressed. But to my knowledge, at 300 Holman Street, there has been no multi-day event since the unifier, which was 3 years ago. All the other events have been single-day events, to my knowledge, and they've all been well below the capacity that was at unifier. I would be the first to say that I wouldn't want another multi-day event. I sat in the audience 2 selectmen meetings ago when the one on Howard Street was given, and here they were with the same problem, and it hadn't been addressed. So I hope we do address it as the Board of Selectmen, that a multi-day event is the problem. The way to curtail some of this is through the entertainment license. I believe that we should limit the amount of entertainment licenses to any one property owner, not per property, but property owner. If you're one property owner and you own 6 properties in town, you still get the same number, and then you can limit it. We can discuss what that number is. Right now, there is no limit. So there are other ways to get rid of and resolve the community conflict there and the tension. And I hope that people can come together to do it. I just don't think zoning is the answer, because I don't think that what he's doing has broken those things. The other thing is, you know, what are the things people are complaining about? Is it the number of events? Is it the number of people at the events? Is it the noise? He provides parking on his property, so it's off the street. The police on this event for the entertainment licenses that the Board of Selectmen approved several weeks ago took that into consideration. He met with the public safety officials. So there is parking on the property. Let's say there was no music. Let's say you just had 250 people, rolling 250 people, maybe not 250 people at one time, but people come and go in a multi-hour event. How many people, if you had no music, would that be a problem? Or is the music the problem? Then we can put restrictions on when the music is. You know, I think a lot of parameters, and Dr. Massey came up here earlier and said he's willing to work with all these people. When he put the zoning article by petition on this town meeting, he did it at the request or the proposed solution by the planning board, saying that's the way to resolve it. He didn't do it because he said, oh, I want to change the zoning of his own volition. And he pulled it because he didn't think that was the right thing to do at that point. But he was talked into that was a resolution. That's a way to resolve the problem in front of him. I would urge this board to overturn the decision, okay? And let's go back to establishing guidelines about what would be in the parameters of a proper residential use, of number of uses, and some of these guidelines of specificity so that it would give guidance to the whole town. Thank you.
Thank you. I have one question, Mr. Alonso. You had mentioned that when you were a selectman, you were on the board when you approved the entertainment license for the unifier event. Just a question. This board, when we do things, zoning things, when we issue a special permit, we often put conditions, many conditions. Did the selectmen put conditions on the entertainment licenses? Do they limit hours? Do they limit when the music has to go off? Do they limit campfires? Do they limit loudspeaker and noise? Do they condition anything?
I'd have to it was 3 years ago, to be very honest, and I don't recall. I would have to look at that. I know it was discussed so I don't know. I think, if anything, it was the music, when the music was. I think that we took consideration of, especially. But I don't know particularly what hours it was that we allowed it. What my comment was at the time, and I mentioned that I wasn't even sure that the applicant at that time, that we were the proper board to come to, because we have no authority at that point. And I purport now that the Board of Selectmen still doesn't have the authority to give a multi-day license. You'd have to give 3 separate entertainment licenses. We don't have a multi-day license permit. So and I asked the applicant then, I'm like, how come the person's before us? Under what authority are we granting this license then? But that is very different, that we do have entertainment licenses. The 3 that the applicant, that Dr. Massey is looking at now, the one for the photography exhibit and the 2 separate ones for Friday and Sunday for the Pride event, are very specific, and they're very time constrained in the afternoon, 2 of them, and one of them is like a campfire, as he said, a cook fire. But those definitely fall into the purview. I want the Board of Selectmen to come up with, and they've been working on a special event permit license, but that's still in the constructing period. We still haven't adopted it.
Okay, thank you.
Thank you.
There was a young lady I said was next.
Hi, Jennifer Johnston, Richards Way. I'm just a resident of Lunenburg, and my concern would be, as the building commissioner stated, what's appropriate for a residential area. I wanted to move to Lunenburg because it's a nice, quiet town, and I can turn out onto my street from my driveway, and I can sleep at night because I don't live next to a concert venue. I'm not concerned if there's 4 to 10 cars out front because my neighbors are preparing for a bake sale or having a Cub Scout meeting, but I would when it's getting to be 200 to 500 people that are showing up and coming and going throughout the day, and I can't walk my dogs and I can't get out of my driveway. So that would be my concern, is that when it's starting to get to that point where it's just so overwhelming to the neighborhood and it's a non-conforming use of the residential area. And then one of the things that I like, kind of being new to town, was at the town meeting, I remember a member of this board being there asking for the ZBA to have more jurisdiction over like the solar farms and so on, because you would do a better job of protecting the residents of Lunenburg. So I'm hoping that's the case here as well. Thank you.
Thank you.
Hi, I'm Chris Barilli, 484 Holman Street. I'm in a butter. I'd like to clarify a statement that was made by the speaker, not right before, but before that. I believe he said that there have been no multi-day events since Unifier, which was held in 2017. And actually, in your packet, I believe I'd point you to September 14th, 2018, the Connecticos event. That was a multi-day event with 99 attendees, and no entertainment license was requested. I'd also point to the fact that of the 29 events, 8 of them had ticket sales. One of those, being the Unifier event, my calculation grossed over $100,000 in sales. That's way beyond residential use. And the last thing, I've heard a lot of people say, well, it's 140 acres. Yes, it is. But only 2 or 3 are actually used for these events. So I'm on 2 acres. There's no difference between my property. Maybe it's 2 or 3 or 4 acres, but it's not. They're not using 140 acres for these events. So let's stick to the facts. And the last thing I would say is that it is a dead-end road. One of the previous speakers talked about how 2 cars can't even pass by. Well, but 250 event goers going down a dead-end road, yes, there might be enough parking, but you've got 250 cars or 125 cars going down a street that's not even wide enough. So I would just ask you to, consider the facts. You have that in front of you, and there are ticket sales. There have been multi-day events without entertainment licenses, and I just ask you to kind of consider that. Thank you.
Thank you. Anybody else? Mr. Massey?
Thank you. Just to place on the record just some facts. To start, yes, Sandra Lane kindly did sell this to me. Of course you could deny this. Of course you could close down what she asked me to do. We can do that. I don't think that's a good and wise response that we could do as a community. I ask you again, kick it back to the commissioner. Sit with him. I've demonstrated a track record of modifying and modifying and modifying to attempt to meet most people's wishes. I'm certainly looking to meet all reasonable terms. I've demonstrated that. To answer your question, the unifier, there were terms. We attempted to meet them. I requested people to leave when they violated any of those terms. That was the first permit we got. That was my first experience. I'm much more the wiser. Now, I proposed photography, as you can see. Photographs are quiet. I've proposed a reasonable small pride celebration, attempting to modify and over-modify and over-modify. So I ask you, kick it back. Let me continue to try, meet Sandra's requests from me and my approach to her of reasonable events. I listen very clearly to anybody who speaks here. I re-listen to the tapes. I approach the town and say, show me a solution. So I'm now before you, asking you to kick it back so that we could come up with a reasonable solution. And again, if it doesn't work with Sandra's wishes, my request with her, with the properties, so be it. But again, it's a loss for this town. It's a loss, I believe, for everyone in this room, under reasonable conditions. I'm not looking to block anyone's driveway. I'm not looking to block up the road. I'm looking to meet the Chief of Police's terms, Chief of Fire's terms, Conservation terms, Board of Health terms. To all the points that have been mentioned, the facts do matter. Again, to my request to come out, see the property, see the facts. The bridge has been mentioned, the width of the road has been mentioned, the size of the property. See the facts. Come see the facts in use at the photography event. Kick it back. Let's do this photography event, indoors, whatever terms, and come see how that works. Again, to speak to the term of what is the number of reasonable accessory use. I've always said, just give me a number. Let it be 4, let it be 6, let it be 10, let it be 2. Just give me a number. I'm so grateful for some words that I heard tonight that made sense to me. Just offer clear terms. It's been 4 or 5 years. We've all been looking for clearer terms. Maybe this is an opportunity to get some more clear terms. Kick it back, explore the property. Happy to take those terms. And then the commercial, it was mentioned I'm not a good business person, but I've come and purchased the land and I've put in money to offer these people to come to the events, whether it be the flower garden people, whether it be the library, whether it be the historical society, whether it be even people here. There's the hockey kids I've offered it to, and that's one of the gentlemen in this audience who's one of the coaches. Just set reasonable terms. Let's come back here in a few weeks. Either let the photography thing go and we can see how that goes with terms, or without the photography. Let me sit with the commissioner and let's come up with terms and we'll come back. We'll say these are the terms. Or not.
Okay. Thank you. Anybody else?
Good evening, Steve Weaver, 288 Holman Street. I'm sorry about Paul also.
Oh, thank you.
I wanted to bring up a instance when after Unifier was done, Mr. Massey went back to the Board of Selectmen to apply for another entertainment license. It was denied. And Mr. Bob Ebersol at that time said that if, somebody has a wedding at their house, if they have it every single weekend, it gets abusive. And it's intrusive also. So, I think that, that is what we got going on here. Mr. Massey came and applied for an appeal in front of you people back in, I believe it was 17. He had to withdraw that because it was going to be denied. It is a zoning issue, and we're asking you people to please help us. And the reason why it's a zoning issue is that's why Mr. Massey, who is very smart now, because after he was denied the entertainment license, he just held the events himself, 29 events. And then he begs for forgiveness afterwards. He goes and builds a stage on top of Mulfus Brook without getting permission. And then it has to be torn down or talked to by the town manager. And also, to show that he wants to run events, that's why he was introducing the citizens' petitions, to try to bypass you people, and so that he wouldn't have to worry about zoning. And, but when he went to get approval from the planning board, Tana Cole and Paula Bertram, they recognized that he was trying to do a function facility. And that's what they called it, a function facility. And that's in complete violation of a residential area. And by the way, I was at that planning board, and all three members voted down not to be in favor of that petition going to the town, even Matthew Allison. Okay? So, I also want to say that one of the letters that was written tonight by the Conservation Commission stated that there shouldn't be any parking in the conservation area. Well, on Mr. Massey's website for his events, when he gives directions to his events, it says, when entering from the south, park in the parking lot. And that's the south side of the bridge, which is on my side of the road, which the only parking lot there is the conservation parking lot, or park on the public way, which they can't do because there's no parking signs along that way. So his directions is telling people to park in the conservation area. And I can tell you, because I monitor that a lot, that there is a lot of violations that go on with cars parking illegally down there, and on the public way. So I wanted to point those things out. Also, on his website, he has the Tenderness Resort, which, again, states as though it's a function facility. And, with function facilities, you can hold all kinds of different events. And that's what he wants to do, is hold all kinds of different events. you could probably have, the high school basketball team there, the Cub Scouts. You could have the Hells Angels there. You could have Devil's Disciples Clubhouse. Anybody that wants to hold an event there can hold an event there. So, I think that zoning is the key issue. And where you people have denied it before, not denied it before,
I'm
sorry.
going to correct you.
Right.
They withdrew
Withdrew.
without prejudice.
Correct. So I think that you should deny this appeal also, because I think that the building inspector has done a champion job. I also know that even though he owns 140 acres, a lot of it is up the side of Holman Street, and there's only like 20 acres or so that are used for the events with parking on either side. And all of that parking, I don't know what kind of environmental effect that has, because a lot of his land is wetlands, and I don't know if some of that runoff from the vehicles and some other bacteria or contamination that may go down into Mulfus Brook. And that goes right into Hickory Hills where our town wells are. So I think that that's very, very serious. And I commend you people for holding up the bylaws. Thank you so much.
Thank you.
Okay.
Would anybody else like to speak, please? I'm sorry. I get you next, I promise.
Jeanette Sullivan, 501 Holman Street. I want to start off by thanking the gentleman for his services that he spoke about earlier. And I'm going to echo a lot of what other people have already said, that a lot of us have already have been living there for a long time before Mr. Macy moved in. We all purchased our homes for our own reasons. I was a single parent of an adopted child for reasons I'm not going to discuss now, needed to very quickly find a home. And when I found 501 Holman Street, I knew it was exactly the place that I needed to be. It was quiet, it was private. I have lovely neighbors, but at a distance. It was just, it was beautiful. It's still beautiful. 300 Holman Street, beautiful property as well. When it came up for sale, when Mr. Macy was looking at purchasing the property, there was already discussion of it being used as a business. They were talking about day spas or resorts. So it was already in the plans that they wanted to change a residential home into something more business-like. I've had conversations with Mr. Macy. We've talked about different things that he was planning on doing. I made it clear that I was going to stand my ground, that nice conversations, but it's my property that is in a residential area. I bought it for a reason. Probably the oldest house on the street. Not really going to be able to sell it very easily if I wanted to. So I'm kind of stuck there, and I'm going to do what I can to protect it. I think I'm very friendly with Mr. Macy. I walk my dogs up and down Holman Street all the time. I stop and offer to help when he needed it. We have conversations, like I said. I try to be neighborly, but I think in respect that he also needs to respect our properties and what we were looking for. I think that's it. So, thank you.
Thank you.
Jane Gallagher, 9 Valley Road. I feel like I was just here. And It was in regard to sort of making an exception and setting precedents on our zoning. So I think that we have to think long and hard about that. We're homeowners. We're in at Valley Road is in an area that is zoned residential. Mr. Massey bought a home that is zoned residential. The simple fact that he just stood here and said he has to keep making modifications on events, I guess, that's taking place at a home. It's not something I'm doing. If I throw a graduation party, it's one day. I have a few friends over. It's done. I'm not making modifications of any sort. So I get the impression that even he's admitting that there's more going on, I guess, than sort of meets the eye. And I would hope that you would uphold what the building commissioner has proposed. Thank you.
Thank you. Does anyone else? Go ahead.
Hi, my name is Derek Matson. I live at 4 Windermere Drive, and I'm in a butter. I have 1 acre, but it's beautiful too. I'm before the board today because I'm in full support of the building commissioner in that the events that are happening and continue to happen just need to stop. They've been going on for a long time. There's been some comments about how many per year, what's the average per year? Is it 6, is it 7, is it 3? How many are there? How many were real events? How many happened? How many didn't happen? And I think that the residents of Holman Street and the abutters, as far as establishing the proof, we've lived it. We're all here. We're all here to tell you what's happened, to speak firsthand as to what happened. We know what's happened. The interesting thing is the events that are coming up, we talk about how many per year. We're talking about 3 events in a 1-month period, right? So, I mean, it's really hard to gauge how many come after the ones that are only a month away. There's 3. Are there going to be 3 in the following month, in the month after that? Where does it stop? And I just don't think we know. And I really have 2 different perspectives of how I look at this. One is as an abutter. There's a lot of comments today, some people who are abutters and some people who are across town with good points, but they're across town. And what I say to a lot of people is walk a mile in the shoes of an abutter and feel this day in and day out. And yes, we all invested in these properties and we all expected zoning laws to be upheld. And our lifestyle, I've been there for 18 years. So this is a hiccup that we weren't expecting and we're not happy, right? We're not happy and we need help to protect what we've invested in. The events in the past, maybe even with the best of intentions, have had a creep factor to them. The questions came up, were there criteria, were there contingencies for these events? Well, there sure were. I sat in on the meetings, before the events happened a couple of years ago with a quiet voice and listened and said, let's see what happened. And then I experienced what happened, right? The 4 days. Well, it wasn't 4 days. People came in days before and were camping for days ahead of time. They weren't supposed to. Vendors came in days before. They weren't supposed to. Attendees camped and vendors stayed days after, and they weren't supposed to. And nothing really came of that. So the 4-day events turn into 5, 6, 7-day events, and things you're not expecting really creep. We understood that the noise was being held by a professional outfit and that there's these studies and PowerPoints on how it's pointing this way and no one's going to hear anything. And the peace and quiet comes into play with these things. I work out of home and 1 o'clock on Friday afternoon, the sound check came on, right? And literally the walls shook. I said, I'm not going to jump to any conclusions. There were discussions at the meeting. There's a number to call. If the noise gets loud, we'll turn it down. I called that number a lot of times, and the noise didn't get turned down. And I got young kids, We had the windows closed, and you could feel the bass coming through hundreds of yards of woods. So it was a long night. Lessons learned, adjustments were made, but, the first night, shame on the event holder, but it happened Not just Friday night, it happened again on Saturday night. It happened the night after that. There was no adjustment. You know, there were people walking around in the woods, like we said, some people doing open fires in the woods. I had people 25 feet from my property line. We did have the police come out and talk to them. And the only reason I bring it up is I heard, you know, we were labeled as complainers and unfounded reports. Well, I have to disagree, and I have to let you guys know that they were founded events, and the unknown is concerning. You know, what's going to happen at the other events? What's going to happen when there's a Friday event and then a Sunday event? Is nobody going to stay over those events? I don't know. I can't speculate. But the creep factor and the unknown is what's scary about this. And that's why it has to stop. The other viewpoint is, when you look at what's happening, we have a great case study of what's going on this property, on Holman Street, on Windermere Drive. We talk about the zoning issue. We talk about the zoning laws we have in place. And there's proposal to change the zoning laws. Maybe this can happen on anybody's property, and anybody can navigate that. Well, I tell you, what we have in this little area, I wouldn't wish on my worst enemies. We should quarantine the whole area until we get this figured out. This is crazy. It's turned this neighborhood upside down because of what one property is trying to do. If we introduce this and let this creep to Lunenburg into several different areas, this town would tear itself apart. I think it's easy to say we're complainers, but I think if other people had to walk a mile in our shoes and understand what we're going through, what we have tonight, what we've been dealing with for the last year, it would be introduced times 100 in this town, and what a mess that would become. So I asked the board to look and respect our current bylaws, to respect what the building commissioner has done and how he has protected us, and I ask for you guys to do the same thing, and I thank you for your time.
Thank you. Would anybody else like to speak?
Good evening. Francisco Ventura, 2 Windermere Drive. I have 2 young children, 3.5 and 4.5. And I want my rights protected as a homeowner. I ask you, gentlemen, to please support the commissioner's decision. He is doing the right thing for, not just for our neighborhood, but for the whole town. I'm a new town resident, 2 years in town. I run a big banquet facilities. That's what those type of events should be held, not on a residential home. Thank you.
Thank you. Anybody else? Seeing none, I'm going to cut off public discussion. Okay, well, I'm going to bring this back to the board. Again, we did say that we would use the Mullen Rule, so we will continue this hearing to June 12th. I believe there is another hearing scheduled at 7 o'clock, so I would make it at 7:30. I'll need a motion to continue.
I'll make a motion that we continue to date certain, as mentioned.
June 12th at 7:30.
I'll second that, Mr. Chairman.
All in favor?
Aye.
Aye. Okay, so the hearing will be continued to June 12th at 7:30. And at that hearing, we will open it up again. And what will happen is there is a 5th member of the board who, as I explained earlier, is out of the country. And what he will do is he will watch all of the tapes. He will watch everything that we did tonight. I will open it up again so that he can ask any questions that he may have. Again, we may bring up some more questions. We did get some new material submitted tonight. I'm sure that the board is going to review all the material. So we will open it up for a small period in the next hearing, and then we will take a vote.
Mr. Chairman, should we address the question about the June 8th event as what might have been requested, or?
I don't think if we're not taking a vote, that's going to be up to the building commissioner to decide at this point. He has a cease and desist that he has issued, and he's going to have to deal with that.
Thank you.
Any other questions? With that, I will ask for an adjournment. Motion to adjourn.
I'll make a motion that we adjourn.
All in favor? Second?
Aye.
Aye. So, hopefully we'll see you all again on June 12th at 7:30.